I'm going to put you back on mute, Shannon. If you need to talk to me, just unmute. So I'm waiting on one last audio connection, like Mr. Garcia's.
There is a new date that should be.
Now we lost Mr. Garcia. Let's see what happened. Sean, if you're talking to us, you're muted.
No, Judge, I actually just I actually went to court for a motion because the other counsel was in court. So we.
Okay. Mr. Garcia, can you hear me? Doesn't look
Yes,
like
Your Honor.
Oh, okay, good. All right, looks like we've got everyone back on Garcia versus Garcia. I have read the ADR specialist's report. Was there any more you wanted to add, Mr. Kelly?
Yes, Your Honor. There's a few things. As you can see, clearly outlined, the conciliator had concerns with defendant mother's recent suicidal tendencies or mental health or anger issues, her verbal and physical aggression towards the plaintiff that's occurred with the children present. And it's interesting that this morning it's made to sound like none of those things are really an issue or really did occur. But as the court had reviewed the report, she acknowledges these things to Ms. Harsh. Ms. Harsh didn't pull these out of thin air. She acknowledged that she harasses dad. Since this response was filed, Your Honor, my client's got over 40 text messages from mom of varying degrees. Some of them indicated that she now knows where he's working, making bail threats about his work, causing trouble at work, to where he had ended up ultimately blocking her from that further communication. She acknowledged to Ms. Harsh she threatened to punch him in the face. I've seen her anger firsthand. When she came to pick up her summons and complaint from my office, she went on and was yelling and swearing, and Mr. Garcia had to be backed away from her because it looked like she was going to assault him at that point in time. If she's going to do that in my lobby, what do you think she's going to do when other people are not around? She has acknowledged that she's vandalized his automobile. I believe one of the kids was in the car when she did that. Then she said she's going to start dating his girlfriend's ex. And I know Mr. Carroll represented to the court this morning, oh, they're just friends. Well, Mr. Garcia shared with me this morning, apparently a profile pic of these two from October showing they're in a relationship. And then he provided a text message just from December 10th indicating They broke up, but they got back together because she couldn't stand to be away from the guy. It's troubling that you would go out and search out your ex's current girlfriend to start dating their spouse. That's disturbing to me, Your Honor. And then you throw in the text messages, which were not from 2019. They were from just this last year. And these things have happened more than once. She's actually verbally said these things to my client as early as this summer. You can't ignore when she says to him, and if you read the text messages, I'm sure the court had already done so before. There's no antagonism going on from Mr. Garcia. He's not baiting her. He's not name calling. He's not making light of the situation. He's trying to assist her to get through this. In doing that, she's responded by saying, excuse my language, but this is what these texts say: fuck off. I don't want help. I want to fucking not be here. The help I want is for someone to just kill me. And he's going on to say, you need to get help. You need to get some assistance. Then she had an issue with apparently getting a user ID. And he said, what's going on? And she says, I give up. I can never win. He goes, what happened? She goes, I was born. That's what happened. These aren't things blowing off steam. This is pretty concerning. And he's asking her, is there something I can do to help you? She says, hit me head on with your car and make sure I'm gone. I need you.
Mr. Kelly, I did read that.
Okay.
I wasn't able to tell. I don't recall seeing a date on it. Do we have any verification anywhere as to when those were sent?
I would request Mr. Garcia to respond to that question, Your Honor, because he provided me these text messages. I believe they were from earlier this year. Mr. Garcia, could you respond to the court?
2019.
Yeah, I can look right now.
I'm going to step away for just a minute. I'll be right back. So, Mr. Garcia, were you able
I was
to find
able
the
to
date?
find the dates. Yes, Your Honor. There was an instance on December 14th of 2019, one on January 28th of 2020, and then one on March 2nd of 2020.
The one I'm most interested in is the date of the text messages that are attached to Mr. Kelly's filing.
Those are all with those. The hit me with the car is on December 14th, 19. And then the I want to die, DIE, is from 1/28/20.
Thank you. Mr. Kelly,
Yes, Your Honor. And continuing on, I find it pretty disturbing. Is Mr. Carroll says, is she a threat of harm to the kids? I don't know. Our ex parte motion wasn't about changing parenting time. Our ex parte motion was more about, at that point in time, her leaving to go to New York with the children unplanned, and us having contact with her family in New York who had no idea she was coming. So we have more concerns with her mental health and what she's going to do to herself, because you have a 9-year-old, a 4-year-old, and a 2-year-old who would be completely defenseless and utterly scarred if something were to occur in her care and custody. If something as simple as not being able to get an email link sets her off, or coming to pick up a summons and complaint sets her off, it's concerning what could happen. It's interesting if she doesn't have these issues, that she's apparently recently enrolled herself in counseling and aggression intervention, which is part of the conciliator's recommendation. I think, Your Honor, if you're faced with the same type of factual scenario in a child abuse and neglect case, with the agency requesting those same type of recommendations, along with a psychological evaluation, which I think would be beneficial for this court to know, is she what her current diagnosis is, because she has told my client she's bipolar. Also, to determine if she's a danger to herself, if she's a danger to others, and what would be a recommended treatment. I think that would be very beneficial, considering the ages of these children, for this court to take into consideration in making a determination moving forward as it relates to any type of a parenting time schedule that she would have. So I would simply request of the court to continue the order that's currently in place, get that psychological evaluation completed by mom with those certain questions answered, as I just referenced. I think we need to get an update from her counselor. What is she telling her counselor? What are they actually working on? If you're going in because you're going through a divorce, that's not really the issues that I think the court would be concerned with. I think that's all information I think the court would need to have before changing anything in this particular case. Thank you.
Judge, if I may briefly respond.
just a second before you do. So Mr. Kelly, the one thing I'm having trouble understanding is if, based on what she heard from the parties, the ADR specialist believed that the mother was a danger to the children. Why did she give her any parenting time at all?
Your Honor, I read it as the ADR specialist was more concerned that the mother was a danger to herself. I mean, if the court can point out in the conciliator's rationale where she felt she was a threat of harm to the children, I must have missed that. I did not see that. I took it more of her concerns had to do with her behavior directed towards dad, but also the statement she made about her own mental health and mental well-being and harming herself. I didn't read in the conciliator's report anything that she was a threat of harm directly to the children. Our concern is her doing something to herself with the children present if she has one of these episodes again. That's why I was requesting a psychological evaluation, so we can see exactly what is going on in her level of functioning, to determine if something further needs to happen from the court.
Who's going to pay for a psychological evaluation?
I would submit that would be mom's expense.
Mr. Carroll?
Judge, I think I agree on the same line of thought that the court was. If this gentleman was worried about mom's safety with the children, or even mom hurting herself, Why didn't they file an objection to the report themselves? The most recent circumstances we have with any of these texts, according to Mr. Garcia's own testimony, is March. Well, that's 7 months ago. From March all the way through October, they were exercising a 2-2-3 schedule. Where's the more recent stuff? Where's something to suggest that that she was ever going to do it other than, like I said, blowing off steam? What we don't have, and now that I hear it the way he describes it, where's all the phone calls where he might have been talking to her, goading her into making these texts? We don't have that. But I do know Mr. Garcia did attempt to hang himself in 2017, and a hospital was involved, and he was transported by an ambulance. But we're not trying to take away his parenting time because we hope he's under control, but we know he's drinking to excess. So there's conditions of that. Why would we get into anger management? Because it's already in order, Judge. The order specifically says that we have to do it within so many days. My client's not afraid of education. She has no problem getting into those kind of classes. I don't know what the circumstances are. I rarely ever, in fact, I never have clients on the other side of the divorce come to my office to pick up paperwork because they probably don't even know why they're there entirely. They may have been told something entirely different about, hey, come to this attorney's office, meet me about something. And that to me can never be a good situation. And I don't want it in my office. Perhaps Mr. Kelly has good luck with that. I don't know. But I think that's a little, you're going to surprise her with the divorce. I don't know that that's the best way to go, let alone one that had an ex parte motion attached to it, which would have made it much more frightening to begin with. So I don't know what happened there. That's not in their pleadings. You know, they added that today. She does see a counselor because, again, it's part of the court order, and she's addressing this. Whoever the person was in March, where's the evidence that that's continued at all to this day? Nowhere. What we do know is we have nothing involving the kids being a problem. If the court wants a psychological, order that they each get a psychological evaluation. Clearly, Mr. Garcia's got some kind of problems going on because he attempted it once and he's drinking to excess that he's losing his job. I mean, a job that he was making 60% more than he is now, maybe 70%. I would suggest that there's still some things going on between these parties that in the way they interact with each other, that's probably not the most healthy, but that's how they interact. The kids are, from all I've seen, are doing fine. They love mom. They love dad. They should see them equally. And if they don't see them equally, my mom should at least have the midweeks because she's not a danger to these kids. I don't believe her to be a danger to herself. We've given you a letter attached from the doctor she even works with, who is also the doctor that prescribes her medication. So if we had an issue, we would see it there. She doesn't have bipolar. This is Mr. Garcia, unfortunately, making allegations without any foundation. Does she have PTSD? She does have PTSD. Many of our U.S. Marines do. I bet you Mr. Garcia has it too. So, Judge, I think that it needs to be changed. In going back to the idea of support, the support would need to be changed correctly too. How they ordered it when they were exercising 50-50, that she pay the same amount that she would be if she wasn't, I don't know. I think they did it retroactive because the court recall when I brought the motion for holidays, I wanted to at least start getting support paid because they were exercising 50-50 at that time. And the court said, oh, what I'll do is I'll just make the support retroactive to August 1st. Well, problem is they did 50-50 all the way through almost the entire month of October, but the front of the court made her pay as if it's the parenting time she has now all the way back to August 1st, which that doesn't make sense. They were doing 50-50 all the way up through the time of the conciliator's recommendation. So again, either 2 midweeks in addition to what she has, or go back to 2-2-3. We don't fear any psychological evaluation. In fact, I'd be kind of interested in having one on Mr. Garcia. I don't know that these folks have that kind of money. Now that Mr. Garcia's, he's making 60% less than he was. My client barely makes 30 grand a year. I think that's about what his income is. Thank you, Judge.
Briefly, Your Honor, Mr. Garcia did not attempt suicide. I don't know where Mr. Carroll's getting that because he had an ambulance ride. That did not occur. Instead, he was actually talking with Ms. Garcia about the concerns that was going on in his life. And again, that was 3 years ago, and he has since got help. He's stable. He doesn't have any issues. In regards to Dr. Van Wagenen, he is a doctor of internal medicine. He is not a mental health professional. He cannot be prescribing her psychotropic medications because he is a doctor of internal medicine. She would have to get those from someone else. The letter that was attached is that letter from him, that doctor who is not trained in the mental health field. So I think that should be given little to no weight whatsoever. Your Honor, you've seen the text messages, what they are. It's disappointing that they're being completely minimized, but at the same time, it must be concerning enough for her to get into counseling. If you're filing objections to these recommendations that you don't agree with them, I don't know why on earth you would start complying with the recommendations unless there is an underlying issue there. Thank you, Judge.
Judge, the recommendation is in order. It's already in order. You already signed it. I have to comply with it. So we do. The medication she takes is Xanax. Her doctor can prescribe Xanax, Judge. That's not a psychotropic medication. Take a look at the text. The medication that Jeremy tells her to take a Xanax, just like you did. That's why they were prescribed to you in California. Xanax is not psychotropic. That's in the, maybe Mr. Kelly didn't see that. That's what's in the text. That's the medication. That's not psychotropic medication. That's for people suffering from depression, anxiety. There's unfortunately a lot of people prescribe Xanax for that exact reason. So there's no psychotropic medication. She's not on that kind of prescription.
Right. So I step back and take a look at this situation. As I read through the conciliator's analysis, I see a highly emotionally charged relationship with a lot of emotion after the end of the relationship. There's ample reason to be concerned about both parents, given many of the allegations that are in here. But the parents who knew about all of this stuff voluntarily entered into an equal parenting time arrangement. Where was the concern when that was ongoing? It's only when it becomes a matter of litigation that now all of a sudden these are very serious concerns. Certainly the text that was attached to Mr. Kelly's response was concerning. It was concerning to the court when I read it, but I had no idea when it was sent. Now I find out it was nearly a year ago. And in the interim, since it was sent, Mr. Garcia voluntarily engaged in a equal parenting time arrangement. And it looks pretty clear that at the time Amy Harsh made her recommendation, there was an established custodial environment with both parents. What she did was effectively to destroy that established custodial environment with the mother. Not that there aren't valid concerns here, but there are valid concerns both ways. These parties probably can't afford psych evals. I don't know what they cost, but I'm thinking they're probably in the neighborhood of $1,500 a piece. I'm not going to settle them with that. I do have concerns on both parts, but clearly they didn't have concerns about the other parent when they were doing their voluntary split. So what I am going to do, I'm going to order a return to the parenting time schedule that they were observing voluntarily before this order entered. I'm going to order child support recalculated based upon that arrangement. I'm going to order appointment of an LGAL. I think Mr. Hotchkiss is probably a good candidate in this case. Would either of you disagree?
I have no objection to him, Judge.
No objection to Mr. Hotchkiss.
And as soon as Mr. Hotchkiss has a recommendation for the court, if that recommendation is for a different custody arrangement, we will reschedule this matter. I will conduct an evidentiary hearing. I won't make you wait till your trial. Clearly, there's only one child, I believe, that's old enough for him to really interview. That's Aiden, is that right?
Yes, Judge.
Yes.
The other two are too young, so that's pointless. But, you know, Aiden's got a point of view in here. I'd like that point of view to be expressed independently to Mr. Hotchkiss, and he'll get a chance to interview both the parties. And if indeed his recommendation is for something other, I'm not going to wait for a trial. We'll address that right away.
Thank you, Judge.
Carol, you submit that order?
I shall.
All right, thank you.
Thank
And
you.
let me say to both of the parties, I realize there's been a lot of emotion here. I get that. The sooner you guys do that, and I don't put greater or lesser blame with either one of you, as soon as you can get past that, you need to. Your kids do not benefit from being around highly emotionally charged conversations and exchanges between the two of you. They just don't. I'm assuming, I don't even know, are they doing, counsel, the parenting, I forget what it's called now. The
Nurturing
videos.
parenting?
Pardon?
Did you mean the nurturing parenting or the parenting?
No, the thing the front of the court did. I'm sure they're not doing that.
Oh, they're not. Yeah, they're not. I think this, I don't even remember if they were this schedule, but the SMILE program.
Smile, thank you.
Yeah.
There is a program that's available for online. It does cost you something. And I'm trying to remember the name of that. It's on my desk, so I normally just grab for it and say, I want you to attend this. I want both parties to enroll in
The
this.
high conflict solutions.
Yes. I want both parties to include, Mr. Carroll, do you have access to the web information for that program?
If you, do you have the site there? Mike, do you have the site?
I got the pamphlet the judge provided me. It's called High Conflict Solutions, all one lumped together.com.
Okay.
And then you just click sign up now and follow the on-screen instructions.
So
So
Judge,
there
you
is-
want me to-
Include that in the order. I want both parents to enroll. I want them to complete it. The program will generate a certificate of your completion. Once you've done that, I want you to furnish it to your lawyer, who in turn needs to forward it to the court as well as the other counsel. I want you both to engage in this, and I want you to do it for the sake of your children. It's very informative. It will tell you things about what divorce and separation does to kids that you probably haven't even thought of. It's really hard on them, really, really hard. And anything you can do to minimize that is going to be good for your kids. So I hope you take that to heart, but I definitely want you to participate in that.
Thank you, Judge.
Carol, you'll submit that order?
I will.
All right,